all people are created equal, but all digital personalities may be discriminated by personal data. So the digital personality may be treated as mathematical or statistical object. This is a real risk posed by the algorithmic profiling. So it is a risk of fundamental rights and the freedom of a data subject, and the risk of conflicting the human value of equality. So there are some concrete examples around the world. For example, the social scoring system in China, algorithmic sentencing in the United States by using the compass system, and such is the case in Japan, from my country, so-called information bank system by scoring personal data is being prepared by the government and the stakeholder in Japan. We also saw some evidence on the credit scoring and the social insurance in Europe a few days ago from Algorithm Watch report. So profiling has been long debated around the world. For instance, Council of Europe issued a focus on the automated decision processing in Convention 108 in 1981. The US FTC issued an online profiling report already in 2000, and profiling is not a new subject in the data protection communities. But the automated processing and profiling are integrated part of our digital life and becomes a new stage. Automated processing and profiling itself is not a big evil, but they create unexpected consequences, including discriminations, exclusions, and bias. If this is the case in reality, what we need is not to prohibit all kinds of profiling. Instead, it is a task to remove all the risks surrounding the profiling and automated decision making. So this is a panel what we will discuss and share some good practices and maybe some bad practices as well. So there are several issues to be addressed, such as profiling and automated decision making, explanation of meaning, information transparency, and data protection impact assessment. We should also bear in mind that profiling is not a matter of legal debate. Profiling has some implications on ethical dimensions. The successful profiling meets not only the legal requirements, but also a decency standard to overcome the creepiness of psychology of consumers. So I'm happy to have here today experts to address these problems. I ask all the panelists here to share his or her personal observation. So their remarks do not necessarily represent his or her organization view. Profiling is a controversial topic, so I ask all the panelists here to debate in a decent way, because we will discuss about the decency. So Andrew, yes.
Okay, so yeah, I'm also interested to hear all of your contributions, and then maybe we can come up with some common conclusion about what the dangers are. Sorry. So maybe we just start right away and then see what the debate brings us to. So I think we start with Monique Mann.
Good morning, everyone, and thank you for coming to this session. And I'd also like to thank the panel. I'm really excited to be a part of this panel today. I'm going to approach the issue from the perspective of looking at issues around algorithmic profiling and thinking about how we can challenge this, not only through a data protection perspective, but also from the perspective of anti-discrimination. And I think that this is a really key area that we should be focusing a lot more attention on. So the work that I'm going to present today is building on a couple of projects that I have. One in particular, a paper that I recently published with Angela Daly, looking at digital colonialism, particularly in the Australian context, and some other ongoing work that I'm doing with Tobias Matzner from Paderborn University. So I just wanted to start off with a brief kind of overview and definition about, well, what are we actually talking about when we speak about profiling? So essentially, it's a way of detecting patterns and making predictions on the basis of them. It's essentially a method of inferential analysis that we can use to identify correlations within data sets. The objective here in terms of harnessing algorithms and profiling means that data that's gathered at a particular place and time over specific persons can be used to build group models that then can be applied in different contexts to different people or indeed the same person into the future. It's important to emphasise that the objective of profiling is essentially to differentiate, in other words, to discriminate. And so this is very much at the heart of what algorithmic profiling is about. Around group or category membership, and we're conducting this analysis at a group level. So it's been applied in a range of contexts and social domains: insurance, finance, education, employment, marketing, governance, and from my perspective, what I find very interesting is applications in security and policing. So we've known for some time from the literature, and indeed Helen Nissenbaum was writing on this in the mid-90s, that there's a potential for bias and discrimination in terms of both the data sets or databases that are used and also the algorithms as well. I think what's significant is some of the more recent research actually that's showing that these processes are particularly harmful for racial minorities and other marginalised groups. And this has the potential and risk to result in social sorting and other negative and discriminatory outcomes for these groups. Quite significantly, in terms of sort of the current environment with big data analytics and profiling and machine learning and so forth, this kind of increased data collection and storage and analysis means that into the future, or even at present, some of these biases are very sophisticated, very opaque, and this means that there's issues with transparency, making them very difficult to control for or contest. So we need to keep this in mind as well. Slide. So there's interesting debates within the data protection literature, specifically in the European context, around the ability to challenge profiling through data protection law. And there's, I would say, consensus, particularly from some of the key authors, arguing that data protection rights and also privacy aren't sufficient in challenging or to be able to deal with the problems of profiling in this context. And this is because there's an inherent focus on individuals and identifiable personal data. So there are limits here, and Birchap-Coops also argues that, from this perspective, it's assuming that individuals can exercise control, but frequently this isn't the case. There are some advantages and arguments for trying to view this through a data protection lens, because it introduces rights for data subjects where data are processed, and these rights and obligations aren't found in other fields of law. So I'm not suggesting we do away with data protection law entirely, but I think we should be looking to other fields of law also and other complementary fields of law. So in particular, anti-discrimination, given what we're talking about here in terms of bias and discrimination. And the focus here is much more on the outcomes, irrespective of the actions that led to them. However, in the paper that we've written on this, we argue that in order for anti-discrimination regulation to be effective, it needs to confront the challenges of the new subjectivities, and in terms of the use of very arbitrary and abstracted data. So we have abstract analysis on a range of proxies. So we question whether or not these very kind of sophisticated and complex forms of bias and discrimination do actually map onto legally protected categories. And this is an interesting argument and area, I think. I also connect this to some of my other work in relation to digital colonialism. So profiling inherently involves classifying data and making abstractive inferences according to variables such as ethnicity, socioeconomic status, or gender. These generally reflect wider and long-standing structural inequalities. So I think this entire process is perhaps biased from the outset. So the way in which data collection and analysis is undertaken, it mimics, it reflects, and it extends these types of, and again in particular in the Australian context, colonial practices of segregation and social structuring. In terms of kind of this broader kind of social structure, I think we need to draw attention to, and the potential for creation of new invisibilities, and the new invisibilities through forms of anti-discrimination that may not apply. So in terms of equal basic or fundamental rights, like freedom of expression, freedom of movement, or even the right to have rights, if these are impacted by algorithmic if the individuals impacted by algorithmic profiling are shown to lack these rights, then this is also a new form of discrimination as well. So we're creating potentially discrimination through anti-discrimination, so the argument becomes very meta. So in terms of where we're going with this, in order to be able to harness anti-discrimination approaches, we argue that it needs to confront the challenges of these new subjectivities and suspicions formed by algorithmic verdicts and profiling that use all kinds of seemingly unrelated or arbitrary and abstracted data. We question, whether such data can be used as a proxy for legally protected categories of social identities such as race, sexuality, gender, religion, or actually question whether algorithms create new biases that cannot be reduced to these well-known categories. So the focus here is kind of moving forward, we need to question, well, how do we go about developing new concepts and tools with regard to discrimination in an era of big data and algorithmic profiling? And I think it's really key, we need to examine how we address these practices at a much wider social, political, and also regulatory level. So in terms of the objective of profiling to be to discriminate, a more detailed account of discrimination actually cannot be found in the technology of profiling itself, and it's always discriminatory. This is actually the fundamental reason we're doing it. So in order to distinguish and better understand and challenge different features and classifications as discriminatory, we need to confront these with social and political perspectives. Thank you.
Thank you very much. That's a lot of interesting questions that I'm sure we will have to discuss in the end. But right now I'd like to give the word to Winfried, and he will present the broad overview of the legal regulation, the legal framework. And as far as I know, his presentation is very detailed, but I think we'll all benefit from knowing all the important rules relevant to this matter. Thank you.
Yeah, thank you very much. As you said before, I have a 30 minutes presentation, which I will try to present now in 10 minutes. It is about the legal basis of profiling and automatic decision-making in the GDPR, in the data protection law. And I will try to show you within 10 minutes that the GDPR is not very well prepared for profiling, and that it is not very differentiated when it comes to the certain stages, to the different stages. We have to differentiate when we look at profiling and decision making. These are the definitions used for profiling throughout the last 20 years. So the discussion about profiling and automated decision making is not new. And the definitions of profiling haven't changed within the last 20 years. It is still that which is here shown in green. It's any form of automated processing of personal data. The aim is always to evaluate something, to analyze something, to predict human behavior. And it is always done, or it's always shown or seen as it has to do with personal preferences, behaviors, and attitudes. So starting from the directive, the Data Protection Directive in 1995, until now, the definition of profiling hasn't changed in law. I think, this is now my personal opinion, that we have to be very precise when analyzing, profiling in legal terms, have to be very precise in differentiating certain stages. Of course, every profiling has a first stage which contains data collection. Data collection is done by data provided by individuals or by third parties. It's done by observed data, it's done by derived data, and of course the data have to be stored in a way in order to make use of them. So that is already a stage that is tackled by the GDPR, of course. And the second stage is evaluation of these data by, well, intelligent, more or less intelligent algorithms. And the third stage is automated decision making. And different legal rules, provisions apply to these different stages. And what we have to take into account is these sentences I just will read out, because it's very important that for legal analysis, that profiling is not the same as automated decision making. If a credit score agency develops a credit score, it's another thing if you afterwards are not granted credit because of this negative score or positive score. Decision making is not necessarily automated decision making, of course. A decision, if a credit is granted, is done by a human being. It's not automated decision making anymore. Profiling is not necessarily based on personal data. We all know that. If group files are based on crime rates in residential areas, individuals might be affected, but the material, the input data based on which the profiling is done, is not personal data. So the GDPR does not apply. Then automated decision making is not necessarily based on personal data. If I'm in a queue, at a waiting queue, and I'm drawing a number, this is automated decision making. But of course, it's not very complex automated decision making, and it's not profiling. Automated decision making is not necessarily based on profiling. If you get a speeding fine, and it's done automated, it's not profiling. It's processing personal data, but it's not profiling. And profiling does not necessarily lead to a decision. And not solely automated decision making might also include profiling. Why have I been saying this? Profiling is not specifically regulated in the GDPR. Of course, profiling done with personal data is processing personal data, but there are no specific rules for that in the GDPR. Of course, the whole provisions which apply to any kind of processing personal data apply, but there are no specific rules for profiling. There are specific rules for decision making, for automated decision making, to be precise, for solely automated decision making. If a human being is involved, these specific rules, which you find in Article 22, do not apply anymore. So we have only one provision, Article 22, that deals with a certain kind of our problem we are talking today about. And all the other things, profiling, if done with personal data, are regulated by the GDPR. There are, depending on how you count, 68 obligations on any controller who is processing personal data. And if you do profiling with the personal data, the same rules apply. Many of you might know that. You have to find a legal basis. You have to fulfill the data subject's rights. You have to observe the data protection principles. You have to comply with all the other obligations, and there are special rules for special processing situations. So all these rules apply to anyone who processes personal data and who is doing profiling on the basis of personal data. And then there are special rules, provisions for solely automated decision making, and these are the rules. There is a ban on this, with exceptions, and there is a right to be informed about the existence of ADM. There is a right to get meaningful information about the logic, significance, and the consequences of the ADM, and there is a right to obtain a human intervention. The right to express your point of view, and the right to contest the decision. These are the provisions for automated decision-making only, not for profiling. Of course, in many cases, automated decision-making is done on the basis of profiling, but we have to differentiate it, as I said before, between the different stages of data collection, evaluation of the data, and automated decision-making. So I only have seconds left, probably. I will, because of that, just maybe point out 2 or 3 gaps and flaws of the GDPR in more detail. The GDPR follows the all or nothing approach. Either you have personal data, then the full range of the rules apply, or you do not have personal data. Then nothing is regulated in data protection law. And in my opinion, this is very much too undifferentiated. If profiling is done on the basis of anonymous data, no rules in data protection law apply. If aggregated data on sufficiently large groups are processed, the GDPR does not apply as well. The consequence of that is that GDPR very much concentrates on the input side, thank you, and not on the output side of data processing, of profiling. And I would say it is, especially when we're talking about profiling, much more useful to concentrate on the output side, on the use of the data. One very, very interesting thing I have read in preparation of this topic is that there are scholars who, like Sandra Wachter, for example, and Brent Mittelstadt, who say there should be a right to reasonable inferences. And they say maybe we can, it's not in the GDPR, but it should be done maybe in another data protection law or in a separate law. And I think this is a pretty, we can maybe talk about this in the discussion later, because this is a very exciting idea, but a very problematic idea as well when it comes to trade secrets and freedom of expression. Just last example, when I do a stupid, a very simple profiling in my address book, 500 people, and I want to do a party with 100 people. And before I decide which persons I would like to invite, I give points to the people. Left wing, right wing, intelligent, non-intelligent, good looking, not good looking. And afterwards, I do an algorithmic decision based on giving these people points. And then I invite the best 100 points. Then this is profiling, and it's automated decision making. But it's done privately. The household exemption of the GDPR would apply, but just for the sake of doing this example, I would not like to have someone have a right for reasonable inferences on my decision whom I would like to invite, because it's my freedom of expression, and it's my freedom to decide freely which persons, on which basis, personal, intuitive basis I would like to invite. But if you would demand such a broad right to reasonable inferences, you have to think about the borders of this. Because otherwise you would say to people, you don't like me on the basis of your algorithm? No, I'm not confident with that. I would like to have that you come to another decision and to be invited to your party. Thank you.
Thank you very much, Winfried. That's a very interesting point and also broad framework for the discussion. And now we have Sachiko Scheuing and Claire-Agne Marnier. They have both specific discussions on the specific instances of how we use profiling. Sachiko will speak about the commercial context, and Claire-Agne, I think, more about the political context. So whoever would like to start first.
Good morning, everyone. I'm Claire-Agne Marnier. I'm working at the European Data Protection Supervisor. I don't have slides. And I would like to thank Hiroshi Miyashita for inviting me and giving me the opportunity to present the EDPS opinion on online manipulation and personal data. So, as it was said before, my presentation is really focused on what we call political profiling. I will start by giving you a bit of a context around this opinion, and then I will briefly summarize the subject matter, the main recommendations, and in a third part, I will share with you some of the actions that have been taken since this opinion was published. For those of you who might not be familiar with the EU institution, the European Data Protection Supervisor is an independent supervisory authority devoted to protecting personal data and privacy and promoting good practice for the EU institutions and bodies. And we have three main fields of work: supervisory tasks. So we monitor the EU institutions administration when they process personal data, a consultative task, so it's given advice on EU legislature when they make proposals for new legislation having an impact on data protection, and cooperative tasks. So we work in close collaboration with the data protection supervisory authorities in the member states within the European Data Protection Board to ensure a consistent data protection. The second point I would like to make in terms of context is that under the General Data Protection Regulation, personal data revealing political opinions are classified as a special category of data. So this implies that processing such data is in principle prohibited unless you fall under certain types of exceptions and you provide for appropriate safeguards. As I said at the beginning, I will present you this opinion on online manipulation. It was published on the 20th March 2018, so last year. It coincided with a scandal you have surely heard of, the Facebook Cambridge Analytica case, which has brought data protection into headline news like never before. But as Hiroshi said at the beginning, in fact, the privacy community have been talking about and calling for actions for many years and more specifically in the field of political profiling. In 2005, the International Conference of Data Protection and Privacy Commissioners adopted a resolution on the use of personal data for political communication. And in this resolution, it referred specifically to the processing of what they call sensitive data related to real or supposed moral and political convictions or activities or to voting activities, and to invasive profiling of various persons who are currently classified, sometimes inaccurately or on the basis of a superficial contact, as sympathizers, supporters, adherents, or party. And the resolution called, so it was 14 years ago, for the respect of some key principles in the area of political communication, such as the data minimization principle or the lawful and fair collection of data. The micro-targeting of individuals and groups with specific content, which is based on an analysis of the person's data, is a focus of the EDPS, which has for several years argued for greater collaboration between data protection authorities and other regulators in order to safeguard the rights and interests of individuals in a digital society. The nature of this debate is becoming increasingly compelling given the fears that political campaigns may be capitalizing on centralized digital spaces and widely available data. And I come now to really the content and on the opinion. I will just provide an insight, but you can look at the entire opinion in our website. This opinion is concerned with the way personal data are collected in order to micro-target individuals and groups with specific content, with the fundamental rights and values at stake and the relevant laws to mitigate the threats. It's an attempt to rally the data protection community to help address the root causes of lack of trust in online environment. It voices concerns over the misuse of very sensitive personal data to spread disinformation, exert an influence on voting, and ultimately influence political decision-making. Political parties have always sought to spread their message and influence public opinion. However, while before they had access to only limited data about their constituency, they have begun to exploit the same targeted internet advertising system used by commercial entities by mining the reactions and discussions on social media in real time, and to aggregate data, extract values from these data, such as inferences about personality traits and likely voting behavior of the electorate. Our opinion analyzes how the digital information ecosystem manipulates people on 3 levels. The first level is with limitless and often hidden collection of information about them. Second level, by putting them into boxes, profiles, which cannot be contested. And the third level, by targeting them with information determined by algorithms. The ecosystem which sustains this information is composed of commercial and non-commercial advertisers whose practice are of interest for consumer and data protection authorities. Moreover, platform dominance and market concentration may increase the threats to people's rights and freedoms, facilitating malicious behaviors within the ecosystem that sustains micro-targeting. And this problem is real and is urgent. In our opinion, we conclude that transparency is necessary, but it's not enough. Part of the solution is to enforce existing rules, especially the GDPR, with rigor and in tandem with other norms for election and media pluralism. No single player or sector can tackle these challenges alone. We made several recommendations, such as completing the new e-privacy rules, empowering individuals to exercise their rights. While recognizing that much effort has already taken place, we underline the necessity for the data protection authorities and other concerned regulators to aim at a collective diagnosis of the problem, to understand the local practices of micro-targeting, including to what extent political movements engage in profiling and targeting of individuals, what sources of personal data they rely on, and what tools they employ to profile. We also recommended a better cooperation between regulators, including those responsible for election and audio-visual services. I now present a bit the actions that have been taken since those recommendations were made in the opinion. You are probably aware that the EDPS in 2017 already had initiated the Digital Clearing House. It's a voluntary network which has brought together authorities from competition, consumer and data protection areas who are willing to share information and discuss how best to enforce rules in the interest of the individual. It's the first network of this kind to convene regulators from around the world involved in the enforcement in the digital economy. It was endorsed by the International Conference of Data Protection and Privacy Commissioners in 2017. It's based on the understanding that what I was explaining before, data protection, consumer, competition law, each in theory serve a common goal, but they will be more effective if they work in tandem. And that's why we have proposed to invite electoral and media regulators to participate in the Digital Clearing House, and the next meeting will be organized early this summer. You've heard also probably of the package of the European Commission on the fair and free elections, which recommended also the establishment of networks, election networks, and the first meeting took place in January. And I will finish because I have just 1 minute left, just to announce that we are organizing a workshop. It will take place on the 11th of February. All information are on our website. It's called How to Unmask and Fight Online Manipulation. It's, of course, in due time for the next European Parliament election, which will take place in May, and also numerous national elections this year in EU. And it aims at facilitating a conversation between all those authorities I mentioned, plus media platforms in the fight against online manipulations. And it will be live streamed also. I thank you very much for your attention.
Hello? Yeah. So I'm actually the last speaker of the panel, and I bet you are all very excited to hear my story because, of course, I'm coming from the advertisement sector. So let me just sort of set the scene a little bit, right? First of all, marketing is all about actually two things. So thing one is actually to actually gain awareness of the product or service, to say, hey, I have this product, I have this pen, or I have this mobile phone or whatever. And then the second thing is for companies to actually say, hey, but this pen is better than this other pen, or this pen has got this advantages, that advantages, and so on. So if you want so, in a way, it is a substitute of a sales guy. So it's really important for, particularly if you want to launch a new product, or if you're a new company in the marketplace and nobody knows you, that this tool is available. Now then, back to profiling again. So profiling in marketing ultimately is about, for deciding whether to communicate or not to communicate. In other words, that is the automated decision. Shall I show the ad or shall I not show the ad? And I think what I want to do now, first of all, is sort of deep dive in here, because I do understand that there's a lot of speculation, a lot of misinformation, a lot of misunderstanding in this field. So in order to actually achieve that goal, to decide whether or not to show an ad, I would very generally say you need two steps. So step one is you need to understand your customer, right? So you get an idea of who are those people who are already in your customer database, or who are most likely to buy this product. And I think, things like, relatively old person or high education or whatever, it can be a description of your customer, which is it. And it's very important to actually know who your customer is, because once you know them, you know how to communicate with them. Like, if it's a relatively old person, it actually makes no sense to actually put the advertisement on, say, some app that are fun games or I don't know what. But it is so much more interesting, perhaps, to approach them in by direct mail, or maybe in some communication, even placing a billboard in a strategic area may actually have a better effect. So once again, it is about speaking to or communicating to the relevant person. And I think this is actually very important for the advertisers or the brands, because then if they only communicate with people who are most likely going to be interested in your product, then you don't waste money on communicating with other people. Look, for these companies who are advertising, they actually need, for every person or every place that they're putting up an ad or printing a direct mail or whatever, it costs X euros more. Also, I think on the other hand, it's a really good thing because you have less irritated consumers. People, if you are actually communicating advertisements that are relevant to these people. And now, let me talk a little bit more about the profiling itself, right? We have two types of profiling. Maybe this is how I can describe this. First of all, you have like simple variables. By simple variables, I mean things like, age group between 20 and 30, or has a dog, or level of education, whatever. So there would be single variables. And then the other one is called combined variable or compounded variables. Let me explain. So when somebody is actually trying to select a target group, then you can actually do things like, say, you only send direct mail or display advertisement to those people who are between 20 to 30, has a dog, and has a university degree. You summarize that into one variable, and if that person fits that description, then the answer is 1. If it gets a 1, and if that person doesn't fit this description, then it actually is a 0. So these are the simple compounded variables, simple variable, and then the compounded variables. I think it is just like academic research in real ways. So you have these variables, and what you do is you do analyses that are typically available through different software packages. I'm talking about cluster analysis, factor analysis. CHIDE, I think, is really, really useful because you can actually see the differentiating variables and so on. Through which, what you actually do is you create like groups, different groups of people within the big pot of consumers or whatever the population that is there. So I think you get the point. It's very different from, or shall I say, sometimes you actually have these variables, and you actually have advertisers who say, well, I would like to know more about my clients, and what you do is you do this thing called data enhancement. And that, of course, has to happen in a data protection compliant and in an ethical way. I'll talk about the technical and organizational measures to ensure that at a later stage. But let me then now move on to how we create these variables. Now, at my company, what what we do is, first of all, it is impossible to actually get factual information about every single person in the country or in the city, whatever. So it is driven by statistics. You know, we actually use statistical models. The raw data is typically, responses on surveys, and I think this is tending more towards market research and so on. But the good thing about this approach is that the person who are actually providing this information are aware that that this information is going to be used for marketing purposes. Also very important is another ingredient, official statistic information. Because raw data is quite skewed, you need to think, who are these people who actually go out and say, hey, I want to participate in a marketing research? You know, I think these are very very specific people. So what we do is we actually need to, first of all, and I think if some of you are actually actively doing statistical analysis as part of your vocation, I think this becomes quite familiar. But what you do is you need to weigh the data. So, for instance, if there's an overrepresentation of elderly people in this market research and data, then you correct it so that you weigh answers by these elderly people less, and you give a higher weight on the answers that are given by younger people and so on. And so the entire sets of variables that you generate, you first of all extrapolate it onto the national level. You correct it, and then in the next stage, from different provinces, counties, and so on, you can actually get a statistical breakdown of the population, gender, age, and so on. So you once again, per province, you correct that. Once you have done on the provincial level, you can go one step lower onto the city, and then you go to the town level, and then you go to the street, and then the street segment, and so on. You know, you go all the way down. And then what you have is the first complete file. When you have calculated it, you have a complete marketing data that is an aggregated data on a geographical level. Just to make sure, we actually have this set of rules so that when it is an aggregated data, there is a minimum requirement. This actually differs from country to country, but since Dr. Feil is sitting here, let me take an example of Germany. The National Geographic Data Association or whatever has actually said that to be considered as geographically aggregated data, you need at least 4 households, right? What happens if you actually decided that this, if this particular street segment or cell only contains 1 household? Then what we do is we actually do not use that level data. We actually replace that data with one level higher, the aggregation level that is one level higher. So, and then if you actually have data permissioned on the household level, then we can also actually then project this data onto the household level. But the only difference really that comes out of it are household-specific information, such as if we know, like for instance, how many persons live in the house, or what is the age group, etc., etc., etc. Now let me move on to the next part of the story I wanted to tell you, because obviously with the GDPR and even without the GDPR, when you are an accountable company, then you need to implement several things, and it's very important that measures are taken to decrease the risk. Some of the things that we do, for instance, every single one of our variables are actually going through a vetting system. Using the, since what, 2 or 3 years ago, using the ethical framework. So we not only take a look at, is it legal, it is not legal? No, we also take a look at, hey, is this, does this feel good? If you are to actually explain, if you are to actually imagine your mother, being assigned this variable, would you be happy? This sort of a thing. It's quite extensive. Another measure, I think a major measure that one takes is the technical and organizational measure. Just to make sure, variables, which are descriptors in real case, are actually always separated from a data that contains contact data, be it name, address, telephone number, or email. And the reason why, however, we are forced to keep this sort of data comes from the fact that at the end of the day, if you are, to use data for marketing, you need to communicate. And in order to communicate, you need to know with whom and how you are communicating. So this data has to be there. So to make sure that, however, this information does not, this information is given as much protection as possible, what we do is we maintain a clear separation between the contactable data and the variables. Or some of the variables aren't even personal, as I actually described. It's actually an aggregated data, geographical level data. I think this is also logical because in that way, analysts and data miners can really think with the data, as Marty Abrams, who is the big guru on the issue of data protection, has said already some 5 years ago, so that one can come up with models. On the other hand, if you actually apply that model to communicate, then you use that contact, so action with data, and these need to be separated. Of course, to ensure that, you need to technically and organizationally ensure access control. And on top of that, what we do is, where possible and where it makes sense. Oh, I only have 1 more minute. We anonymize data, but what we systematically do is we pseudonymize the data. Whenever we receive a data, the first process that it goes through is actually the data hygiene and PET, a privacy enhancement technology or tool, and it actually creates a strong pseudonym. And in that way, we within our organization make sure that that data is not being used inappropriately. But in any case, thank you so much, and I hope I made it within that last 1 minute that I was given.
Thank you very much, Sachiko. I learned quite a few things about marketing. It will be useful when I start my own business. Also, I have a lot of questions, but I think first we'll just start by collecting some questions from the audience. So, yeah, go ahead. Maybe just come to the microphone. Yeah.
So this is for Professor Mann. I couldn't agree with you more that there needs to be guidance on how to do discrimination appropriately when using statistical and big data and advanced analytic processes. There was a report issued by by the way, I'm Marty Abrams. There was a report issued by the Hong Kong Privacy Commissioner in October, along with an assessment process for using artificial intelligence and advanced analytics in an ethical manner. And I was just wondering if you had evaluated that to see if it meets the type of political and regulatory guidance you're looking for.
Thank you for the question and feedback. No, I'm not aware of this report, but I will look into it. I think you also raised a very good point, I mean, about whether or not things are appropriate in terms of their use. And I would draw your attention to a very interesting blog post that I recently read by Julia Powers and Helen Nissenbaum, who argued that attempts to kind of perhaps optimize or reduce discrimination actually serve to kind of further reinforce the systems. And so instead of trying to solve these puzzles, we should question whether or not certain systems should indeed be used at all. You also raise a very interesting point in relation to ethics and ethical principles and guidelines. And there is quite a lot of debate about this, particularly from the perspective or arguments around ethics washing, and these kind of ethical principles and attempts kind of enable people to perhaps circumvent or avoid their actual legal obligations. So there's a whole bunch of stuff in there, but I will follow up on that report.
Well, I would suggest you do so, because that's the trend line now with a lot of regulators developing the principles and the methodology. The methodology is actually more important than really the principles, because the methodology is what's then demonstratable.
Yeah, the principles around ethical use of data are important, and we are certainly seeing, this is a very common discussion indeed that I've also been having with people at CPDP, and I've seen on other panels. Again, I would just hesitate that there are actual legal obligations that people have to follow, as opposed to just only adopting this kind of principled approach. And I recognise that there are advantages to both. I also would just like to kind of engage in some shameless self-promotion. Just last week I published a book, a co-edited book on good data, looking at these kind of these ideas. It's free, open access. You can get it from the Institute of Network Cultures, and we go into this, and we actually have our own good data principles in that as well.
Okay, I saw a few more hands, so go ahead.
Thank you. This is one of the most interesting panels I've been in CPDP so far, so thanks. Silvia Conca from Tilt. I actually have a question for all of you, since also the previous question I felt was kind of going around, so I'm going to be the annoying one that actually asks explicitly. What do the panelists think about the AI ethics guidelines about trustworthy AI that have recently come out from the expert group, which, puzzling for me, actually were not based on ethics but on human rights? I'm a jurist, so I'm precise on these things. Again, annoying. And we choose the word trustworthy, and I felt actually what Hiroshi was saying about dignity for me would be a way better framework, even though dignity is an ambiguous term, because trustworthy, as by itself, trust implies a leap of faith, something we don't know. While dignity can actually concretely be boiled down to very good examples. And in this regard, thank you also, Sachiko, for explaining that you actually even use guidelines. I would love to know how you drafted those, like ethical questions that you ask yourself if you asked some other stakeholders, because I do feel that trust and dignity might not get along, and I would love to have your opinion on the draft.
Thank you. Who wants to take that?
Shall I start then while you guys are talking? Because my answer to the first question is actually, I haven't read this document shamefully. Thank you for pointing that out to me. I will have a look at that. In terms of the ethical guidelines and type of the questions that we ask, I believe it is available at the Information Accountability Foundation's website. I believe so. It is okay. So it's for, publicly accessible.
I mean, I would just add some points on this, and a disclosure: I'm not a philosopher. in the book that we co-edited, we did have a philosopher on the team, which was very helpful, and we certainly had a lot of debates around ethics and privacy and so forth. I'm really interested in Southern theory, and obviously, I gave a presentation in relation to sort of post-colonial approaches, and I think we need to also question our systems of ethics and the way in which, particularly from a Western philosophical perspective, and the way in which that we apply those to other groups, perhaps not also from this perspective. So one of, again, in terms of my work in relation to digital colonialism, but then also in the book, we have a chapter from experts who are writing, particularly from the perspective of Indigenous data sovereignty. And so what is ethical from our perspective may not be ethical from others' perspectives. And so I agree that there is a very important kind of distinction to be made there and a conversation to be had. We argue in terms of our principles that good data must be orchestrated and mediated for and by data subjects. And so I think that we need to think about who we're collecting data about and how. And I also would just like to point out also dimensions of the commons and communal data sharing and moving away from these kind of individual approaches. So I guess that's kind of my response. I mean, thinking about this in terms of, well, what frameworks are we applying, where do they come from, and also taking account of other perspectives, particularly those from the global south and non-Western approaches. I have a question. I'm interested in this. I saw on your slide that you had a point around anonymous data or de-identified data does not fall within the remit of the GDPR. I understand this. But I have a question about whether or not the processes of doing this, de-identifying data or anonymizing data, actually counts as an act of data processing. And if so, in that event, would the GDPR apply? And second of all, how would people know?
I mean, de-identify.
Or anonymizing data.
Yeah, of course. It's all about input. If you have anonymous data on the input side, data protection law does not apply. Pretty easy. And if you have anonymous data, you are not able to de-identify them. There is this differentiation between anonymous data and pseudonymous data. Pseudonymous data are re-identifiable. So in the case you have pseudonymous data, it's possible to, in most cases, to re-identify them and to see what individual is behind this data. But for pseudonymous data, the full range of data protection law applies as well. So it's only that anonymous data are out of scope. But I think the question you are raising is, if you have a lot of anonymous data, you may be able to individualize the data set, so that there is an effect on a single person after combining the data, after evaluating them, after having an algorithm running over it. In my opinion, this does not lead to the application of data protection law, GDPR, as well, and that is the gap. That is the gap of the law. Even if you do decision-making, an automated decision-making on a single person with anonymous data, the effect, of course, is on this individual, but still data protection law does not apply. But that's, as all questions in data protection law, is disputed, of course.
Okay, thank you. I saw a couple of other questions.
Hi, I'm Yemi Oviosu. Come from a consultancy firm called Optimity Advisors. We are currently doing a project called Algo Aware, which is trying to raise awareness on the use of algorithms on online platforms. First of all, I must say I very much enjoyed the panel. It was very interesting to hear different perspectives. I have a question regarding just as a kind of follow-up question to that. You talk about these gaps in GDPR, and I'm asking from a position of ignorance, actually. Is it that the GDPR doesn't cover these areas, but are there other legal instruments that do cover these areas where you see there are gaps, or are they generating gaps in the law? Are they completely unregulated? Or does that make sense?
I mean, it makes sense, and this is kind of my point, that we should look to kind of other complementary fields of law. And from the perspective of the presentation I just gave, in particular anti-discrimination, but there are other fields of law that become very relevant as well. And so when we think about things in relation to transparency, intellectual property law and trade secrets also becomes another interesting area. So I don't know if anyone else wants to add to that.
Civil rights law.
Yeah.
Civil rights law has been inserted into profiling
Yeah, of course, there are, for certain areas, certain specifically regulated areas. Consumer protection law might be named as well. Anti-discrimination law, which is, at least in Germany, civil law, where there are certain, where you're not allowed, even between individuals, private persons, to unequally treat on the basis of certain attributes. Like, you are not allowed to get another insurance if you are a man or a woman. And formerly, a couple of years ago, of course, women got better insurance rates because they didn't live so dangerously. That was not disputed for decades. But now the law says no. Insurance has to be the same, car driving insurance, for example, for women and men. So this is a political decision which has been done. But in other fields, of course, not every unequal treatment, even if it's done by profiling, is a discrimination. You are allowed to sell someone to, you are allowed to not sell a product to someone because you do not like him. So that's civil law, consumer protection law, Kartellrecht, Wettbewerbsrecht, I missed the English word.
Competition law.
Competition law might be an area which would tackle with these questions that are rising from the platform problems. Data protection law might not be the right instrument to regulate processing, profiling by platforms, by social media platforms, by Facebook and so on. Maybe the right instrument could be found in other legal branches.
You also raised a very interesting point with your example on gender. I mean, within the GDPR, they do have specific kind of categories of sensitive data in which they can't collect or process, but gender is not actually listed as one of them, where a lot of this kind of in terms of targeted advertising and other forms of profiling does occur along these lines. So there are gaps, and I think in terms of either addressing these gaps through other fields of law or perhaps revising the GDPR, although I don't want to kind of have this argument around defending the GDPR because there was a debate on this yesterday, but I think also you drew attention to work such as the right to reasonable inferences and also arguments around counterfactuals.
One political remark to this question, there is a huge fight about what is the aim of data protection law. Some say it's privacy, others say it's informational self-determination. Others say it's about discrimination. Other people say it's about informational asymmetry. It's about the power of organizations. It's not decided. It hasn't been even discussed in the negotiation process of the GDPR. I was taking part on the behalf of the German government in the DAPIX negotiations. It was never discussed. The fundamental question, what is the aim of data protection, was never discussed on a political level. Many scholars demand that data protection is on this or that. And they very strongly have opinions on these several or different aims of data protection, but we don't know it. And in the end, many people say, we don't have to discuss it, it's all in the law, we only have to interpret the law rightly. When it comes to those gaps are denied by many people, and they say, no, we only have to interpret this legal term in a way in order to come to the right solution, which is not a good way in my opinion.
And I would just kind of riff off this or add to this. I mean, I think data protection has real limits in terms of actually addressing some of the social justice issues that arise from new technologies and new processes of analysing large amounts of data. Certainly in my work, which was recently published on the topic around digital colonialism and information imperialism, we look at a series of case studies in relation to the use of these types of systems, and quite significantly and consistently they target the most vulnerable and already marginalised parts of our community. And there are a number of examples that I can speak to on this within the Australian context. We're kind of leading inverted commas, some of this because we have an absence of any enforceable human rights protections at the federal level, well, at all really. And so things like systems to identify or raise debts from welfare recipients, targeting of Indigenous individuals through public access computer surveillance, which was happening during the intervention. Things like cashless welfare cards. I mean, I could just go on. There are so many examples in which these systems are specifically and particularly from the administration of government and public functions designed and targeted towards vulnerable communities and groups. And in many ways, they're using these vulnerable communities and groups as somewhat of an innovation playground, if you will.
Thank you. Do we have any other questions from the audience? If not, then I noticed that Hiroshi has some question he noted down, so maybe let's hear.
No, I don't have a question, but since we have only yes,
5 minutes left.
Yes, 5 minutes left. I should make a remark on this. My findings from the panelists. I think there are three things I have found by myself. The first is profiling is based on aggregated data. So, but the GDPR covers only the protection of an individual. So, do we need a protection for the groups or classification? As an academia, I see the new book, Group Privacy, published by the Dr. Lynette Taylor a few years ago. So, do we need to take care of these kind of group privacy in the future? That's the first thing I noticed. The second thing is a risk-based approach. You mentioned, Sachiko mentioned about the use of anonymization, but we understand there is always a gray zone, particularly the output data. What's anonymization in terms of, the classification group profilings? The third thing is how to make a bridge between the data protection law with other laws, such as election law, anti-discrimination law, consumer protection law, competition law, and the basic fundamental philosophy of human dignity. So it's a huge topic beyond my predictability of the panel discussion, which I found by myself. So thank you very much for your participation. Thank you for joining our panel. Thank you very much.